In this video, we are going to discuss about sedition. In IPC, there was a provision, section 124 capital A of IPC, and now there is section 152 of BNSS. So, what changes are introduced there in BNSS, and what is law of sedition earlier and now? We will discuss every element of sedition, the important case laws, the historical background. So let's begin. Now first section 124 capital A of IPC, which used to provide law of sedition. From 1st of July 2024, now Bharatiya Nyaya Sanhita has been enforced throughout the country. So the earlier laws are not applicable. But we are going to discuss this provision because there are certain cases which are also pending. There is a challenge against 124 capital A, which is pending before Honorable Apex Court. So this law is being discussed, 124 capital A, because there are cases which are pending, and for those cases even the Honorable Apex Court is deciding this matter. And as currently there is a case which is filed against to challenge the constitutionality of sedition, and that is pending, and the Apex Court has referred this matter by an order to have a larger bench for the same, as the earlier law in Kedarnath has been challenged, and Kedarnath was decided by 5 judges bench. So the 3 judges bench of Honorable Apex Court has referred the matters to 5 judges bench. So that will discuss later in detail. Now 124 capital A provides, whoever by words, either spoken or written or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt. So signs, written words, or something written, or even the visible representation of anything or otherwise, brings or attempts to bring into hatred or contempt. So by all of these things, anybody brings or attempts to bring into hatred or contempt, or excites or attempt to excite disaffection towards the government established by law in India. So this is, so the provision says that the perpetrator must be doing any of these things, that he's uh, bringing hatred, contempt, or either exciting or attempt to excite disaffection towards whom? The government established by law in India. So this offense is against the government which has been formed by law in India, and the same can be done. The act can be done by words, written, signs, or visible representation, or by any mode. Doing what? Bringing hatred or contempt, or exciting or attempt to excite disaffection towards the government of India. Now, those are the main elements of the provision, and this is complete definition of sedition. There are explanations, but before that, the punishment provided is that shall be punished with LI, to which fine may be added, or imprisonment which may extend to 3 years, and to which fine may be added, or with fine. So this either he can be imprisoned to 3 years, or otherwise also to LI. That depends on the act done, the gravity of the offense committed. So this is 124 capital A, sedition in IPC. Now coming to the explanations. Explanation 1 provides, there are 3 explanation in the provision. First provides, and it defines disaffection. So there is a term used there in 124 capital A, disaffection, and that includes, the definition is not given, but they are saying that disaffection includes disloyalty and all feelings of enmity. Now this disaffection was discussed in a judgment in Queen Empress versus Bal Gangadhar Tilak, which is a landmark judgment of that time, and Justice Stretchy held that disaffection means hatred, enmity, dislike, hostility, contempt, and every form of ill will towards the government. And disloyalty is the best general term comprehending every possible form of bad feeling to the government. So this definition, after this explanation and that judgment of disaffection, this term disloyalty and feeling of enmity was added in the explanation. So therefore this was added later on. Now, explanation 2 provides comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempt to excite hatred, contempt, or disaffection do not constitute an offense under this section. So, disapprobation, comments expressing disapprobation of measures which government has taken, or anything done by the government. Any person just wish them to be altered, any measures taken by the government, and anybody wish them to be altered, and anything said or expressed by him in that regard, and that is also done in a lawful manner, the required, the wish to alter the same, any expression made on that regard must be done lawfully, must be mean very lawfully. That expression of alteration must be in a lawful manner without exciting or attempt to excite hatred, contempt, or disaffection. This thing cannot be sedition. So, sedition is not something which is lawfully said, anything against the government, especially for what government has done is not liked by anybody, and any expression made by any person having disregard to the measures taken by the government, and that person's object is to alter the measures taken, and that too in a lawful manner, and that expression cannot in any way excite or attempt to excite hatred, contempt, or disaffection. That will not at all be the sedition. Now, explanation 3 is similar to explanation 2, but it provides for something different. It says that comments expressing disapprobation of the administrative or other action of the government without exciting or attempt to excite hatred, contempt, or disaffection do not constitute an offense under this section. So it says that disapprobation, any expression disapproving the administrative or any other action of the government, and that to express in a manner without exciting or attempt to excite hatred, contempt, or disaffection, that will also not be sedition under this section. So this is clear that everything said by the any individual against the government cannot be sedition. Now, origin of sedition is from England. The sedition came into existence in England. This is a concept of Britishers who also brought the same in India. And this was the seditious remarks against the ruler to remove him from power was punishable as sedition. So whoever used to say anything against the ruler at the time of king ruleship, and anything done to remove the ruler, that was begin to be punished as sedition. So then during 16th century, sedition developed as words or writings disaffection towards the state or its constituted authority. So even for the sedition begin to used as offense against the government constituted as per the law. And then in India, the sedition was drafted by Lord Macaulay, Thomas Macaulay in 1817. And this was the time when the India was struggling for freedom. So this is the origin of sedition. It is a concept of England. Britishers had this law at first, and then it was introduced in India as well. And interestingly, this law was way before was already removed from the penal laws of England there. So even the England has removed this law of sedition. Now in Tara Singh versus State of Punjab, AIR 1950 SC 124, the sedition was held unconstitutional, being violative of Article 19(1)(a), which provides freedom of speech and expression. And then after this judgment, Parliament amended Article 19(2), which provides reasonable restrictions over the rights provided under 1. And in the interest of public order was also added by first constitutional amendment. So just to reinstate this section 124 capital A, this amendment was introduced, which provided a restriction over right to speech and expression, which was 19(1)(a), on the basis of which the 124A was found unconstitutional, as it did not, as it was hindering the right of freedom of speech. But in the interest of public order was introduced, and afterwards the Kedarnath judgment in Kedarnath, the constitutionality of the same, on the basis of in the interest of public order, which was introduced by first amendment, this section was again held constitutional. Then Kedarnath was decided in 1962, and the Honorable Court held that this offence is generally known as the offence of sedition, occurs in Chapter 6 of IPC, offences against the state. This species of offence against the state was not an invention of the British government in India, but has been known in England for century. Every state, whatever its form of government, has to be armed with the power to punish those who, by their conduct, jeopardize the safety and stability of the state and disseminate such feelings of disloyalty as have the tendency to lead to the disruption of the state or to the public disorder. So you see, the public disorder was used to justify this provision, which was introduced by First Amendment to 19 Article 19 Clause 2. But also it was held in Kedarnath judgment that there must be incitement to violence or tendency or intention to create public disorder in order to prove that an act or a speech is seditious. For that, happening of actual violence is not necessary. So it is not like that the actual violence should happen for sedition. No, only the intention of the perpetrator to create such a situation where violence can be there, public disorder can be there, due to that incitement, due to any speech expression made by him, that alone is sufficient. Now, very importantly, mere speech is not also sedition, where in Balwant Singh versus State of Punjab, it was held that mere sloganing which evoke no public response did not amount to sedition. Where an individual people are using some slogans, that is not something which makes itself a sedition. There must be a public incitement of public disorder or violence, and that should be attended by the public. So just because somebody's sloganeering is not sufficient to attract this provision. Now, in Kedarnath judgment, with regard to right to speech, the Honorable Court also held that citizen has a right to say and write whatever he likes about the government or its measures, but by way of criticism or comment, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder. So it is clear that right to speech is not hindered, but there is a restriction that the speech should not be exceeding to such an extent where the people are incited to violence against the government, and there is no intention of, if there is no intention of creating public disorder, then the speech is well protected, and that should be subject to those limitations. There are batch of petitions again got filed under before Supreme Court against 124 capital A, which is sedition, and this the name of the case is SG Wombatkare versus Union of India, and this is the WP number. And here, after this filing of this petition, the Supreme Court directed the state governments and the central government to keep all pending trials, appeals proceedings arising out of the charge frame under 124 capital A to be kept in abeyance. That means that no further proceedings should be done against the cases arising out of the FIRs under section 124 capital A. Now, Supreme Court in this case has recently, while passing an order to refer the matter to a larger bench, has considered and accepted this fact that the Kedarnath judgment did not consider about Article 14 and 21. The Kedarnath judgment only considered and discussed about the fundamental right to speech and expression, but it nowhere checked whether the sedition is constitutional from the aspect of 14 and 21. So that's why it requires reconsideration, and therefore the Supreme Court referred the matter, 3 judges bench referred the matter for reconsideration by 5 judges bench, and this is the order. You can find it out this on the website of Supreme Court. Now further in Jasbir Singh versus State of Punjab, the same thing was as we earlier discussed in Kedarnath as well, that merely using abusive language does not automatically amount to sedition unless it incites public disorder or violence. So this was upheld again in Jasbir Singh versus State of Punjab. Then again, it is held that criticism of government policy is not sedition. In Zakir Hussain versus Union Territory of Ladakh, it was held that the criticism of government policies, even if strongly worded, is not sedition unless it has the potential to disturb public order. So now, biggest problem with the sedition is that the party in power misuses the law for political motives. As recently in case of Vinod Dua, who is a journalist, FIR against Mr. Vinod Dua was lost for his commenting on the prime ministers regarding how he was handling the COVID-19 crisis, and sedition charges were imposed. So it was held that it was a criticism of the government, and his comments could not be termed as seditious. So, as it didn't have those qualities of inciting the public disorder or violence. So, this is how the sometimes, and there are many cases where the political party, government in power, have misused this provision there for their political motives. So, this was one of those cases. Now, recently, Law Commission of India has given its 169th Law Commission report, and in the same, the Law Commission has supported the provision, has stated that this provision should not be deleted from IPC, and gave its reasons for the same. Now, regarding misuse of the law of sedition, the Commission has backed it and has stated following things. Now, number one, it says that while the political class may be accused of misusing the sedition law, the root of the problem lies in the complicity of the police. Sometimes, in an overzeal to please the political masters, the police action in this regard becomes partisan and not as per the law. So the law commission says that it's equally the responsibility of police to see the law as it is, and should not kind of, as the police pleases the political people there. So it's the responsibility of police, as it is the police who registers the FIR. Secondly, it states that it is often said that the offense of sedition is a colonial legacy based on the era in which it was enacted, especially given its history of uses against India's freedom fighters. However, going by that virtue, the entire framework of the Indian legal system is colonial legacy. So this is very rightly said by the Law Commission, as our 90% of our laws are given by the and prepared at the time of colonial time, as our even the current IPC was also that framework prepared at the time of British era, like Transfer of Property Act, like so many other acts which were prepared and uh, enacted that time. And then says that each country's legal system grapples with its own different set of realities. Repealing section of 124 capital A of IPC on mere basis that certain countries have done so uh, is essentially turning a blind eye to the glaring ground realities and existing in India. So as we say that most of the countries, progressing countries, have done away with this provision, but saying that the law commission says that it's not practically wanted in India, as the realities of India says that this provision must be there. This is the view of the law commission. Now coming to the new law of sedition introduced in BNS, and section 142 of 52 of BNS provides, which is under chapter 7 against the state, offense against the state, and it provides act endangering sovereignty, unity and integrity of India. So the marginal note has been changed. The provision 124 capital A used to provide sedition. Here it is providing act endangering sovereignty, unity and integrity of India. So it says that whoever purposely, knowingly, by words either spoken or written, or by signs or visible representation, by electronic communication or by use of financial means or otherwise, excites or attempt to excite cessation, armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life, or with imprisonment which may extend to 7 years, and also be liable to fine. So you see that even the new law of sedition in fact looks like more wider than the earlier provision in IPC. And then again, the offense, the punishment provided has also been extended, increased. As earlier there was 3 years or LI, but here it is 7 years or LI. So even the punishment has been increased. Then the terms used like secession or armed rebellion or subversive activities. These terms nowhere defined in IPC, the new BNS, or the feeling of separatist activities or endangers the sovereignty or unity and integrity of India. So, what is separatist activities endangering sovereignty or unity and integrity of India can be very wide. It may be very wide interpretation of those things. Now they have given this explanation. They have combined both the explanations provided under 124 capital A. So explanation 2 and 3 are combined here. They say that the disapprobation of the measures or administrative or other action of the government with a view to obtain their alteration without exciting or attempting to excite the activities referred in this section do not constitute an offense under this section. So the explanation is a combination of explanation 2 and 3 of 124 capital A, as we have already discussed. Now we are going to discuss about the sedition and treason, as both terms generally are used interchangeably. But both the terms are different and their definition and their real meaning is very different. So sedition is a state crime that involves inciting people to resist or rebel against the government in power. Whereas on the other hand, the treason, a federal crime that involves acts that are considered dangerous to the security of a nation or sovereignty. So here the sedition provides, if you see, that sedition is generally against the government in power, whereas the treason says that this is a crime that involves danger to the security of a nation or the sovereign. So it is the then second provides ultimately its ultimate object is to incite public disorder which may result in violence for causing disaffection towards the government in power. So again, inciting public disorder which may result in violence for causing disaffection towards government. On the other hand, in treason, the security and sovereignty of a state is put to risk, where the culprit targets the very state itself with an attempt to overthrow the government as well as the general public by waging war to affect the sovereignty and security of India. So you have seen the difference. There is a difference as the sedition is just against the government, affects the government in power, whereas treason affects the nation and its security, its sovereignty. So considering the new provision, section 152 of BNS, whether it is really a sedition offense of sedition or it is treason, considering and examining both these concepts, let me know what is the real nature of this provision, whether it is sedition, treason, or it's blend of both. Thank you so much for watching. If you like the video, please subscribe the channel. Thank you.